Me mentioning?
My lord, may I have my lord's leave to mention one testamentary matter. Witness action was going on, my lord. Cross-examination of my client's witness.
Inclusion.
Yes, my inclusion as witness action. I am mentioning upon notice.
Commercial Division, item number 1.
Last occasion, Lordship granted me leave to file the corrected list of documents. May I file that, my lord?
Who is your other side?
The defendant was appearing on the last time. I don't know, my lord. I am appearing for the plaintiff, my lord. May I file?
Have you served copies?
But I will serve them right now, my lord. They appear, or else I'll serve them in the course of the day.
List of documents filed by the defendant, by the plaintiff, be kept in record. None appears for the defendant. Fix. 26 February for framing of issues.
Item number 2.
And I appear for the defendant.
Mr. Bose, he's on his way. This matter could stand.
Any hearing?
Yes, it was on the point.
I'll finish.
No problem.
Hearing on?
I am in cross-examination of the witness. I had shown him a document and sought to tender it, and Mr. Bose raised an objection. So that objection, Your Lordship was hearing. I made submissions one day. Your Lordship had asked me to prepare a note. I prepared the note. I'll just remind Your Lordship briefly of the matter. The point is, memorandum of understanding. I showed the witness. He said, yes, this is the memorandum of understanding. These are the signatures. All that was exhibited. But when I went to exhibit the document, objection was taken. It is not adequately stamped or registered, and it cannot be done. So we let that happen. Thereafter, the main conveyance was tendered, and they agreed, and the main conveyance was tendered. So now I have raised the issue that since the transaction was completed by several instruments, if one of the main instrument is registered and stamped, then, my lord, there is no necessity for the earlier instrument, the MOU, to be again stamped. And therefore, that objection as far as stamp and registration is concerned is not valid. And I argued it when Mr. Bose said, yes, in principle, he agrees with my argument. But his contention is now that that MOU is not the, relates to the same transaction as the conveyance.
That is separate.
That is something to be decided at the suit. So Your Lordship had asked me to prepare a note. I prepared the note with the copy. Note.
We also have our notes below. The issue is below whether this is stamping or not below.
Deal করবেন আমার কেসগুলো deal করবেন
We don't দিয়েছে and we also have Millard respective.
So we'll exchange the notes today and come back if necessary. But if I may just show my note, I'll just explain very briefly what it looks very big, it's very short. And this is only to the issue of whether these two documents are to be exhibited. That's paragraph 1. Then, my lord, I've given the question numbers where we sought to tender the documents. Now,
let me go through it.
Yes, I'm just showing it so that Your Lordship.
Which para you are referring to?
No, I'm just, if my lord takes the first page, this is the issue. I'm not placing the issue. Then this was the arguments. These are the relevant question numbers. Your Lordship will see when I sought to tender it. If my lord comes to the third last paragraph of page 2, this is where in the conveyance, these page numbers will show the conveyance specifically refers to the MOU and the other agreement. So those two page numbers are important. Thereafter, section 4 of the Stamp Act I have set out. All the set out is in italics. That's why it's taking space, basically. And then, my lord, from page 4 onwards, I have referred to 3 judgments. And I've set out the relevant portions for my lord's convenience. That's why it looks a bit long. But in the italics portion, the paragraphs are set out. I've also annexed the decisions, the reported decisions as well. So it's a very short point.
Milord, I also have prepared the notes. Milord, may I hand up along with the judgments? There was no direction for exchanging of the notes, Milord. If he cites a judgment formally, Milord, he
I
has
am
given
citing
me-
those three
Milord,
judgments on
three
the last
judgments.
day also.
If your lordship takes,
There
Milord,
to note
the
it.
point. আমাকে দিয়েছে copy তো? কোথায় দিয়েছে? দিয়েছে আমাকে copy? We have it.
এই তো,
May I give a note to my lord?
very
Milord, there are
stingy.
two documents in question. Milord. Those are, Milord, Memorandum of Understanding dated 9th of May 2017, which is on a stamp paper of ₹100. And there's an agreement dated 8th of June 2017 on a stamp paper of ₹100. Those are annexures A and B to the written statement. So, Milord, who is, Milord, putting them on board? It's a defendant is trying to put them on board as an exhibit. So, Milord, there are ways and means, Milord, to, Milord, put it, Milord, on as an exhibit, Milord. He can, Milord, prove it by his witness, Milord, whatever way. Now, Milord, as confrontation in cross-examination of these documents, he wants to exhibit the same. Now, Milord, admittedly, Milord, this is, Milord, an unstamped document, Milord. This has not been registered or stamped, Milord. Inadequacy of stamping is the issue. If there's an inadequacy of stamping, section 35, Milord, of the Stamp Act come into operation. My learned friend's contention, since the main deed is now registered under the provision of the Stamp Act, it need not be, Milord, stamped and registered, Milord. It's admissible in evidence. That's the, in Bengali, we say mota point of his argument. That is the sum and substance of his argument. Now, Milord, under Order 13, Rule 3, Milord, now if your lordship takes the Order 13, Rule 3 of the Code of Civil Procedure, Milord, it says, Milord, that how a document has to be exhibited, Milord. And, Milord, this is if the document is unstamped, it cannot be, Milord, looked into for any purpose at all. This is going on, Milord, right from 2009, Milord, the judgment, Milord, SMST, and, Milord, we follow till the, Milord, recent NN Global, Milord. Now, Milord, may a reference to a memorandum of understanding or an agreement of sale in two deed of conveyance does not permit some unstamped document to be, Milord, put in, Milord, by way of, Milord, exhibit, Milord, if it is, Milord, inherently, Milord, defective, Milord, or, Milord, some.
No, the argument of Mr. Ghosh is that when there are several documents,
Yes.
starting with from MOU or agreement for sale or whatever that might be,
Absolutely.
culminating into a final conveyance.
Yes.
Now, these are documents pertaining to same transaction.
There is a memorandum of understanding.
Hmm.
That is what, Milord? It is not even like an agreement. It's, Milord, a prelude to the agreement, Milord, like MOU, where, Milord, parties agree to various things, Milord.
Hmm.
Milord, it may not culminate into the conveyance, Milord. That's the case. Conveyance is, Milord, the ultimate, Milord, thing which the parties have got, Milord, and we have to straight is because if there's a registered document that has to be looked into, not the unregistered document. That's the law on the subject, on the Evidence Act as was then, Milord. Now, Milord, there's a Supreme Court to that effect. If your lordship takes page 5 of my notes, kindly have a look at it. Kindly take, Milord, the reference to a judgment. I just placed the paragraph. It is respectfully submitted, Milord, serial number 11, that two unstamped document cannot be exhibited for any purpose. Even for the purpose of identified signature, the two documents cannot be exhibited. Rejection of exhibits are clearly permissible at this stage. Milord, serial number 1, Milord, may a reference to memorandum of understanding and agreement for sale in the deeds of conveyance does not permit unstamped documents to be exhibited, and I have relied on a judgment of the Supreme Court. Milord, if there is a Supreme Court to the effect, Milord, I did not cite anything more, Milord. And I have given it specific. This was the specific
Which
case.
judgment you are referring to?
Milord, 2009 to SCC 532. I have given compilation. I have given a compilation. It's like this, Milord. It looks like this.
2009.
9 volume 2 SCC 532.
Which paragraph you are referring to?
Paragraphs. Lordship will kindly have a look at page 6 of my notes. Let's 7, 12, 13, 14, and 17. 23, 24, 25. And it's a copy of these. বলবো যে আমি পড়ে আসছি জজ সাহেব। হ্যাঁ দিচ্ছি দিচ্ছি স্যার 1 মিনিট দাও আমার কাছে আমার কপিটাই দিচ্ছি।
Paragraph 22.
Yes, Lordship will look at the paragraphs at page 6 of my notes. The paragraph numbers I have given. Mr. Bose is there with the Lordship
Yes.
will permit him to take over.
I will eagerly hear Mr. Bose.
Which also certifies that his one is illegal.
You won't undermine him. Yes, 22.
Willard, kindly have a look at. Willard, kindly.
You can continue.
No, let me. 1 minute. अरे ठीक है. Kindly have a look at the judgment in question. George sir, note. Only Willard note. Mr. Kindly Willard permits it. He is there,
My
Willard.
lord, whatever has fallen from your lordship, I have tried my best of my ability to formulate the points, and I have answered each point.
You are plaintiff.
I am the plaintiff. My lord, plaintiff's witness is being cross-examined. My lord, plaintiff's witness is being cross-examined. 2 unstamped documents disclosed by the defendant is sought to be proved through my witness. My lord, has your lordship got it? My lord, so my lord, these documents are unstamped documents, cannot be admitted in evidence. But signature, he is a party to signed. Now, my lord, obviously, when he is confronted, is it your signature? My lord, the signature portion is admitted. Your lordship, I have given a case that even if you prove your signature, document does not get admitted at all. I've given some case law to that. 1. The latest judgment on this, your lordship suggested one judgment which I have mentioned. My lord, Sonu's case. Subsequently, Justice Dipankar Datta, very recently, 3 months back, has passed side saying no matter of consent, even if I give consent,
You cannot give consent against law.
against law because you are destroying the fiscal statute. It is to protect. That is the language. I've included that on this. May I just quickly brush through the points? The paragraph numbers also I have indicated. So, my lord.
It is here.
Yes, everything. Every last one. My lord, so what I have done, my lord, if your lordship takes the notes, because, my lord, otherwise your lordship will read the notes. There is no point. It will go on. Then, my lord, your lordship will ask us. Otherwise, it will be wastage of time. Yeah.
Let me do one thing. Let me go through these judgments.
Yes.
Go through this.
No, may I just, I won't take. I will take exactly, my lord, maybe 12 minutes. Because the 12 points are there. Reading. Or less than 30 seconds if I can read.
Yes.
My lord, basically paragraph 1
Of
this note, I have set out, my lord, the 2 documents which are sought to be exhibited through my witness, not relied by me, relied by them in their written statement. Through my witness, they are proving some documents on, my lord, 100 rupees and 10 rupees stamp paper.
this is a disclosed document.
In the written statement.
That is defendant's disclosed document.
This way, defendant's disclosed document. So, my lord, this is a disclosed document. No doubt about it, disclosed document. But I have not disclosed. I am the plaintiff.
Yes, but defendant's disclosed document.
Now, 2 is paragraph 2. Just read it, my lord. Just. There is no reference to the aforesaid documents in the plaint. My witness is in the box. Then, witness of the plaintiff is being cross-examined. My witness is being cross-examined. On behalf during cross-examination, seeks to admit the 2 documents relied upon by defendant number 1 and disclosed by the defendant through witness of the plaintiff. This itself is not permissible in law. My lord, which law I do not know, but I think this is a fundamental principle. I tried to get a case which I couldn't get. And some case, English case, I have not been able to get hold of it. My
You
lord,
can refer this, I can search it out.
no, it was not available. We tried all.
The sentence doesn't make sense. Disclosed by the defendant through the witness.
Yes.
I have disclosed the document. I have confronted him. The witness has signed that document. He admits it.
Yes, yes.
This sentence
Disclosed-
doesn't make sense
My lord,
at all.
sought to be admitted,
Correct?
then this itself is cannot be cross-examined on which is not admissible for want of. My lord, has your lordship last sentence. My lord, if your lordship is paragraph 3, he said a party cannot be cross-examined contents which itself is admissible for want of stamp. Then, my lord, paragraph 4, the two documents were, however, shown to the witness. Now I have referred to section 3C of the Indian Stamp Act and says that every relating to property is chargeable with duty mentioned in Schedule 1. My lord, Schedule 1 of the Stamp Act. And for West Bengal, there is an amendment which says that 1A, it says that agreement, this sort of agreement memorandum are chargeable with the same duty as a conveyance. I have set out the provision. My lord, entry 23. My lord, your lordship can say that it's 7% of the market value. Now, my lord, pausing here for a moment, just for your lordship's thing. My lord, these properties, then section 35 I have mentioned, my lord, I have set out. My lord, section 35. I have said in bold that no instrument for any purpose. Has your lordship seen that, my lord? My lord, paragraph 5.
Yes.
Then, my lord, more fundamental is to meet my learned friend's point that, you see, the conveyance is already chargeable with duty. Therefore, the memorandum leading to the conveyance need not, you cannot pay duty twice. My lord, this was the argument. So to that, my lord, my answer is paragraph 6. 6 to 9. And I say that the memorandum of understanding relates to second floor, third floor, and roof will vest in my in the defendant number 1. Then clause 3(1)(c) says that the second party, that is the plaintiff herein, shall transfer entirety, may not note the words, second, third roof at an aggregate sum of rupees 22 crore 58. My lord, has your lordship 22 crore. So all floors basically under the memorandum. Conveyance relates to only a small portion of the third floor. And the amount of consideration is roughly, my lord, 5 crores. So the total consideration, my lord, it is 7% on the
Exceeding 1 crore.
22 crores I mentioned in bold, right? So then I've said in paragraph 7, the agreement dated such and such as 64 states that the plaintiff as Hindu would sell, this is, one is memorandum, another is the agreement, is second, third floor. And here, my lord, the consideration is mentioned as 22 crores. But main thing is second, third, and terrace. 3 portions of the building. Now, my lord, paragraph 8, which is my case, the conveyances which were executed by the plaintiff in favor of side, my lord, refers only to third floor. And that too, my lord, only portion of the third floor. And the total consideration is only 7 crores. So the argument that you have paid the duty once, valid, correct argument. It is possible. that, my lord, if you pay one's duty, then an agreement need not be stamped again, because you will go on stamping. The duty which has been paid is only on 7 crores. My lord, I have total both. Even then, some portion is outstanding. There is a separate suit pending. My lord, kindly see, this is what I've said. My lord, paragraph 9. Since the conveyances of the entirety of the property, being the subject matter of memorandum, have not been executed, and the entirety of consideration as contemplated have not been paid, the memorandum or the agreement which are now sought to be exhibited by him cannot be exhibited, since the same are not properly stamped. Because you have to pay 7% of the 22 crores, not on 7 crores, my lord. Then the two conveyances which have been marked as Exhibit A bear a stamp duty of only portion of the 3rd floor. We're not just repeating, same thing going on and on. My lord, just to drive the point so that your lordships appreciates, right? Only a portion, which is an insignificant part of the entire property. My lord, this is I mentioned. Then paragraph 10. This is important about waiver estoppel. Now on 9 September 2024, my lord, when this is not by your lordship, it was another bench. On my lord, the 9th September, when learned counsel for desired to exhibit 2 documents through witness, objection was raised. Reference may be made to order. Witness, however, identified the signature, my lord, in these 2 documents, which I mentioned in exhibit. And see, please see question 123 and 27. The objection is noted. Noted. Then I say, it is respectfully submitted that the 2 unstamped documents cannot be exhibited for any purpose. My lord, remember the act, the section says for any purpose. Even for the purpose of identity, my lord, it's not identified, identifying signature. My lord, the correction is, it is not identified, even for the purpose of identity. The 2 documents cannot be exhibited. My lord, and rejection is clearly permissible even at this stage. My lord, you can see order, my lord, 13 rule 3, that I can raise any time. My lord, then in small I have said, the mere reference to memorandum in the 2 deeds does not permit unstamped documents to be exhibited. My lord, just because it is reference doesn't mean that the document gets exhibited. I have referred to many cases on this. For any purpose. Remember, my lord, the word is any purpose. Refer to some cases. Paragraph numbers are there. Then, even objection relating to deficiency of stamp duty, it is incumbent upon the court to decide objection first and not to proceed further, which your lordship, faced with this, did. Said now that is why it has been kept for hearing. My lord, it is incumbent on the court to decide objection first. My lord, that is why your lordship has placed it, your lordship's order. My lord, I have given 2 cases on this, just to support your lordship's, my lord, view. Then even for the purpose of signature of unstamped, the document is inadmissible. My lord, even for the signature, document is inadmissible. My lord, I referred to a case, even signature, if you, because then, my lord,
Which one?
my lord, in II, 72 Andhra Pradesh, even for the purpose of signature, an unstamped document is inadmissible. Then I referred to your lordship, told me. Then in Sonu versus Haryana, reported 2017, Apex Court had the occasion to deal with the nature of the documents for which objection relating to admissibility could be waived. All that the Apex Court held was that mode of proof of a document can be waived, but not an unstamped document which is totally inadmissible in evidence. Such objection regarding unstamped can never be waived. My lord, this is the language of Sonu. My lord, And therefore, whether or not signature has been exhibited is wholly irrelevant. My lord, remember the signature with objection, of course. It is respectfully that said signature ought not to have been exhibited unless steps were taken to stamp the main two documents between.
So your point is let this document be sent to impounded, stamped.
That is for them. They are not exhibiting. I am not. There are. If they want to exhibit through their witness, they will exhibit. Through my witness, no. When their chance comes, then, my lord, paragraph 12. I do not want. Who pays the stamp duty? 7% of 22 crores. My lord, kindly see 12. Of particular importance, my lord, this is Justice
Datta's judgment.
Dipankar Datta's judgment. Paragraph numbers, where apex court, in spite of a document being admitted as evidence, my lord, it was admitted as evidence, held that irrespective of whether objection is raised or not, irrespective whether I raise the objection or not, the question of admissibility has to be decided according and allowing a instrument, I quoted from the judgment, with duty to pass unchallenged, merely due to technicalities would undermine legislative and fiscal interest of the state.
Some documents are inherently inadmissible.
That is Sonu. Lordship Bala, it is saying, Sonu is saying, it held that the mode of proof can be waived. The manner you prove a document can
But admissibility cannot be waived.
Never. That is, it says, for unstamped, totally inadmissible in evidence, objection, and I have said
Because admissibility is recited by the statute.
statute, that I have set out the statute. Why? How much it is? And Millard, this is the figure. So, Millard, I'll keep on. What? They have said section 4, they had multiple documents. That only ₹1 is enough. No, I've told you that each document, there are 3 different portions of the property. Total is
3 floors.
3 floors, 22. Main is consideration. Consideration. Main is consideration. 22 crores, 7%.
All right, let me go through all these notes of argument.
My learned friend is behaving like a tax collector. We never used to take these points.
No.
Now Supreme Court helps him. That's why he's doing it.
Yes, the Supreme Court, from our court,
His witness has signed the document, admitted the document.
Part in part,
who is the we, I do not know.
full stop,
Justice
notes of
Supreme Court
argument
also was a we
filed
also.
by the learned counsels be kept in record. Fixed 14 February for further hearing. 14 February will be, I think, too far.
14th February.
That will be too far. 6 February.
6th.
14th February, very auspicious date for people of our age.
My lord will keep it not on the any other day, but 6th.
No, of
I
course,
think.
14 February, I may be missing.
I'm not
No,
embarrassed.
no,
Everyone, for everyone, it's.
I may be traveling.
Yes.
Did I say that? I question that.
14 February is day of reminiscence for all of us at this age.
That I agree. That I
My lord, then
And then
except for the 6th. No, 6th, chhada, any other day. 6th I've got some.
14th.
No, 7th,
10th February,
10th.
10 February. Don't be sad on that date.
Grateful. 10th.
Why 10
But then I will reply to these cases. I have
Let me
also
go through it.
cited.
I may have some queries
Yes.
I have also cited 3 cases.
No, I
My
haven't
learned friend
cited
hasn't dealt.
Because,
I have
one very recently, 7 judges' decision is there on arbitration issue.
on
That
NN
also is
Global. NN Global.
No. This
In
is Justice
re-arbitration.
Sanjay Kishan calls
7 judges bench,
Yes,
Justice
yes, I know.
Chandrachud. That is to be studied.
2004, volume 6 S.
No, not 2004, very recent years.
2024,
24,
volume
yes.
6 S.
Yes.
Page 1. My lord, that is with regard to arbitration clauses.
But there's a reflection on registrability, unstamped documents, all these things. Some reflections are there.
But nothing changes with regard to what I am as a admissibility of documents.
Right.
But only one last,
have had the occasion to.
just to have the last word, Palak, this suit is only relating to the third floor. MOU was that, maybe it's a broader MOU, but third floor, that conveyance is done. The
Correct,
suit is
absolutely.
only to do with the third.
Portion of the third floor.
According to us, the entire third floor, according to them, portion. That is the main dispute in the suit.
I also.
Witness action. Item number 3. Commercial division. Item number 3.
That I appear on behalf of the
Witness is there?
defendant. The plaintiff's witness, my lord. My lord, I was cross-examining the witness on the last occasion, which is on November 21st. The matter was then supposed to come up on December 12th. It did not come up for whatever reason. It's suddenly come up today. My lord, I'm humbly praying, my lord, kindly fix any date, any other date,
Ask
my
2
lord.
or 3 questions.
Very well, my lord.
Yes, you come.
Protein H. AICH.
In any civil suit, you will get some very interesting points. Number of interesting points every day.
It's the beauty.
That's the beauty.
Particularly, I did not know that Mr. Tilok still remembers that he feels sorry on phone.
You also remember, don't say that.
Go back to the
Silently, you remember silently.
Go back to the library and take shift.
Some are vocal, some are not so vocal.
Yes.
Mr. Aich, what has the plaintiff sued the defendant for in this case?
It is the
What has the plaintiff sued the defendant for in this case?
outstanding amount 1 crore 20 lakhs. Something 1 crore 20 lakhs something.
On what basis is the plaintiff claiming this amount from the defendant?
On the basis of ledger, outstanding ledgers submitted by Rilpal.
Who has prepared this outstanding ledger according to you?
This ledger submitted by Rilpal, maintained by Rilpal.
How did the defendant get a copy of this ledger?
Through an email sent by Mr. Kishore Agarwal, director of Rilpal.
He's PW1.
Please speed up. When was this email sent?
I cannot remember exactly. Date
Can you give an approximate date?
Month, year.
2010, year 9.
When was the suit filed by the plaintiff? This suit.
This we have filed preliminary. We have filed what is it called? Winding up application. We have filed first, and that winding up application relegated to suit. Then we have filed that suit.
When was the winding up application filed?
2009-10.
When was it relegated to a suit according to you?
2010.
And after how much time was the suit filed?
That date I cannot quote.
Will you be able to say the date if you look at the records of the suit?
Yes.
Oh, sorry. Last পেয়েছে না আপনার কোনটা আছে লাস্ট ওনার জবাবটা নিয়েছেন Will you be able to tell the exact date if you were to look at the records of this suit?
Yes.
Well, then I'm praying that the records be shown to him, the plaintiff.
No, 2016.
Who has verified this suit? The plaintiff.
Vipasha Banerjee.
How was she connected with the plaintiff company?
She is company secretary of that company.
Is she still working with the plaintiff company?
Yes.
I put it to you, Mr. Aich, that the plaintiff's claims in the instant suit are barred by the laws of limitation. What do you have to say?
No,
I
don't-
disagree.
I disagree.
Let me continue on the next.
PW1 is partly cross-examined. Further cross-examination is deferred to. Date দাও। এই মাসে হবে না। Next মাসে 5th February. Mr. Dotto, that is Bengali Valentine's Day.
Third and fourth are the holidays, so he will celebrate it and then come.
5th is okay or
My junior Millard is little occupied on 5th, because if it can be on any day.
10th, my lord?
10th?
Great.
Regular list. Item number 1.
Excuse your lordship, my lord, I appear for the plaintiff in this matter.
Hmm.
Testamentary suit, my lord.
What about this GS?
My lord, I'll tell you, lordship. We have just been briefed in this matter. Just been briefed. The problem is, my lord, that we have come to learn that the sole caveator, Chobi Laha, has passed away. We tried to serve a notice. Actually, we tried to serve a notice for mentioning before your lordship this matter for inclusion. The advocate record refused to take the notice on the ground. This is an affidavit of service, my lord. On the ground that his client has passed away.
Where it is stated.
They refused service, my lord. They've refused service. They've orally said that Shobila has
Affidavit of service filed on behalf of the plaintiff be kept in record.
So, the stage of the suit, as I can see from the records, was that my witness was getting cross-examined. Executor was getting cross-examined. Now, my lord, there is a caveator. So, my lord, if she has passed away, her heirs has to be brought on record, and we do not know who are the heirs. So, and they are not accepting my notices. The advocate is, of course, after the expiry
Do one thing, send a notice in last known address.
of the
Defendant.
of the erstwhile caveator. If your lordship kindly passes the order to this action, I will do that. Or else, my lord, I have to come back and ask for newspaper publication. There is no other alternative.
It is stated in the affidavit that notice could not be served upon the defendant number 1 and 2. let the notice be sent to the last known and recorded address of the defendants. The suit will appear in the list on 27 February.
Grateful, madam. Madam, one thing may I indicate, your lordship, defendant number 1 had passed away. She's the mother of the wife of the testator. She has passed away long back.
That is to be then name is to be expunged.
Expand that. That's why all steps.
You have
will
not
take.
taken steps.
Madam, we have been briefed only 7 days
Do that.
back. We'll do that.
For the timing, I cannot note that.
Yes,
You send it.
We'll see the records in this.
Yes.
And we'll be granted to see the records.
Leave is granted to the learned counsel for the plaintiff to inspect the record in terms of the original side rules.
Grateful, madam. I'm grateful.
Item number 2.
Item number 2, my application G18 Lord, was substantially heard by Lord Justice Patnaik. We were only to reply back. Lord,
No, we haven't. We have no,
I
never.
release it for hearing.
Lord,
Never, man. Lordship will hear it.
What is G18 for?
G18 is from Lord appointment of administrator pendency light and for accounts. Lord, with respect to during the pendency of this, Lord,
What are the grounds?
probate, the grounds it's complete misappropriation of funds. And Lord, using the Devottor estates, using the
I think I should release it for hearing by Mr. Justice Patnaik. At least this
It
application.
was not part heard before Patnaik.
May not be.
It was not part heard before.
substantial
It was
That's why it is released. Parted matter would not have been released.
ওখান থেকে released.
G18 of
No,
2024.
it is not released. It is determination got
my
changed.
lord
Yes.
is releasing.
Oh, determination got changed.
I am releasing it. GA18 of 2024, which had been heard extensively by a coordinate bench, is released from this court for placing before the bench presided over by Justice Patnaik, who heard it extensively. Let the matter go out of list right now. পিটিশনটা থাকবে, পিটিশনটা আমি রিলিজ করে দিলাম, কেসটা থাকবে। Record of the suit may be placed before the coordinate bench for effective hearing.
Item number 3, 4, and 5.
But this has come at my instance, my lord, on 17th of October 2023.
What is CS?
My lord, what happened, my lord? 2 probate proceedings and my lord, 1 partition suit have been settled between the parties, my lord, by filing in terms of settlement, my lord. Your lordship will see the order dated 17th of October 2023. Okay, here. I was expecting she was not there. Your lordship will see, pursuant to the early order, necessary Vakatnama has been filed. Second page, my lord. The terms of settlement has been filed before this court. The parties are not present personally. However, the terms settlement could be kept on record. Lord, his lordship desired that the parties should appear, my lord. Lord,
This is not a question of appearance of the parties.
Lord,
2
parties
suits.
have signed.
Basically, I cannot take up CS right now because I am exercising jurisdiction or determination of testamentary determination. So let me see what is there.
Same year suit, my lord, within the 2010 and 2020, my lord.
Where is the
suits
settlement, terms of settlement?
are filed in the record. If the records have come, my lord. If they have not come, my lord, I shall give protection, my lord.
Record এসছে? দেখি। Terms of settlement টা কোথায়?
Bond paper আছে। Current paper আছে। Bond paper আছে। এটা আছে।
এইটা, this one. হ্যাঁ, হ্যাঁ।
Bond paper আছে। So this must have been filed in the suit file, not in the probate file.
Yes.
Has been signed by the parties their respective advocate on record. I am the advocate on record.
Now you have mentioned suit number 419. Suit number, is it CS or TS?
CS, my lord. CS.
That should be mentioned, CS. This is confusing. Suit number, both are suit.
Testamentary suit, my lord. 30 and
This
31.
is civil suit. 419 is the civil suit, not
That's a
testamentary
partition
suit.
That's the partition suit.
Yes,
Filed by my learned friend.
that should be there.
But my client has paid the entire money, my lord, as agreed by them.
So there is a settlement between the parties.
Yes.
Properties are to be distributed accordingly.
My client gets a property, my lord, they give up their right, my lord, and my lord, I
Whatever
pay
that might be.
Yes.
There'll be certain distribution of property, certain manner property will be distributed.
Yes.
So in accordingly, this partition suit shall be disposed of. That is so far as CS is concerned.
Yes, and this proceeding can be dismissed, my lord.
This testamentary suit should be dismissed then,
You also can dismiss.
because testamentary suit there cannot be compromise.
This
Either
can
to
be
grant
dismissed.
probate or to refuse it.
This can be dismissed. This can be dismissed. You also can add that, my lord. Because I need a decree, my lord, because there are immune properties involved, my lord.
No, since it's a compromise decree, sign all the pages or come with supplementary affidavit. Come with sign all the.
Give us back, my lord, we can sign.
Yes.
And we shall file it again, my lord.
And second thing, we file it again, mention the suit number.
Very well. Leave may be given so that we can correct, my lord.
Terms of settlement filed by the parties are returned for execution it in proper manner and rectifying the typographical errors.
May it appear on any day, my lord.
All these three suits will appear in the list. How long will it take?
7 days, my lord.
22nd January is okay? Because in that case, we must have to state that these two testamentary should be withdrawn or dismissed.
We shall add it. We shall file fresh terms.
Yes.
That can
And sign all the pages.
That will avoid all the conflicts.
Yes, yes.
As you lordship observe, my lord, they should.
Because in testamentary suit, I cannot pass any decree of compromise.
But we don't want any order in that, my lord.
Yes, so let it be dismissed.
Because testamentary, I was claiming.
Or testamentary suits may be dismissed as withdrawn.
Disposed decree dismissed, my lord. They can be dismissed also. Lord, can they take back the term settlement?
When I fix the date?
22nd of
The original terms will not
Minute.
may be returned, my lord.
ঠিক আছে. Yes. তো dictation দিলাম.
Grateful.
Item number 6.
My lord, I appear for the defendant number 3, my lord. My lord, there were settlement talks ongoing between the parties. Defendant number 3 has sent settlement proposals. Defendant number 2 has agreed to it. Only the plaintiff is yet to signify.
We have certain observation or client regarding the terms of settlement that has not been finalized. If they are agreed to settle, I have no problem, but there's some have to be some on the
Further negotiations are to be
yes,
carried.
yes. And one thing, Mala, if the negotiation can't be done, Mala, can date fix.
Learned counsel for the parties submitted that terms of settlement are ongoing and praise for accommodation. The suit is adjourned to 17th February with liberty to mention. If it is settled in the meantime, mention it.
Otherwise, my lord, we will proceed for hearing of this.
Grateful. Grateful.
Item number 7.
This is my application. My lord, this is an application where a previous in this suit, my lord, there are 3 particular documents, original of which was deposited before court.
was deposited before court, and my lord, those documents.
Who is your other side?
My lord, the other side has not been appearing since 2020. 2022. My lord, there are orders to that effect. If my lord takes up the order of 2nd March 2022 at page 23.
Why Bhabha Atomic Research Center will examine?
My lord, because the particular document was sent to several places. I have attached all the orders, the Central Forensic Science Laboratory, the other departments. I had sent these documents. They have indicated they.
What are the grounds for sending it?
The grounds are, my lord, those 3 documents on the are 3 rent receipts which are claimed to have been executed in the 1950s. But my lord, my claim is that these documents are forged and fabricated documents, which if on forensic examination, it would indicate the true facts, and therefore on the basis of the forensic report, the suit can be decided expeditiously. My lord, I'm led by Mr. Gupta. My lord, will kindly grant.
My lord, this was sent previously on 3 occasions, but the authority to which it was sent returned with the, my lord, report that they do not have the expertise.
You have mentioned annexure GHNI.
GHNI of the.
And annexure bench. H is the order of this court.
No, not those annexures. My lord, if a lordship.
Then how can the other side that if I send it, how they will understand?
No, it's an undefended suit.
I will send it to Bhabha.
Yes.
How they will understand if the copy of this application be sent?
No, not the application. The originals, which has been taken possession of and kept with the registrar originals.
Where are those documents?
It has been annexed. My lord, page 18. My lord, page 16. Kindly takes a look at. Page 16. 16.
Page 16 is a blank document. I cannot say anything on this.
17 is possibly the type.
Where are the originals?
It's with my lord's registrar. It has been kept with my lord's registrar. But may I indicate in 2 minutes, my lord, the backdrop, my lord, of the.
Let me see the documents.
Yes, before that, my lord, may I just indicate in a backdrop the nutshell? It's with the safe custody of the registrar. Pursuant to orders of this honorable court,
the registrar shall produce the documents from the safe custody plaint, GHI of the plaint.
GA1 is the first application where my lord, direction was sought for on the defendants to produce these originals of these documents and to keep it in the safe custody of the registrar. That
Which page? GHI?
I have.
Why don't you mention the pages?
290. Kindly see page 290. Where your lordship is looking at the plaint, my lord, or GA1, my lord.
The 290 kothay?
But we have annexed these documents in this application. But if your lordship is seeing from the plaint, my lord, I do not have the plaint right now.
Very clear, very clean. I can very easily understand those documents which you have annexed.
This is what the defendant had given. So, my lord, it's not.
How can I know which are the documents? Where is the 290 of plaint?
I have annexed that, mentioning this is G. And the page numbers are there. And annexure B of this application.
The learned registrar original certificate application shall ascertain whether.
Would your lordship kindly give me a minute? May I
examination as contemplated in the GA2 of 2024 by Bhabha Atomic Research Center, Trombay, Mumbai. কি বললাম? The examination of the kind contemplated in the instant application by Bhabha Atomic Research Center are carried out by Bhabha Atomic Research Center.
No, I'm praying that it should be carried out. It has not yet been carried out. This is my application appearing for the first time.
আরেকবার বলো সেন্টেন্সটা কি বললাম? এদিকে এসো না। Are carried out by Bhabha Atomic Research Center, Mumbai, in respect of annexure G, H, and I to the plaint. Full stop. Legible copies of those documents shall be sent by the learned registrar original site to ascertain the query. Fixed for further order and report.
One humble submission. From copies, it cannot be ascertained. The originals have to be sent. Because we are
whether these examinations are carried out or not,
but
then the originals will be sent. I am not passing the order allowing the application. Let the matter appear in the list on 6 March.
Would your lordship kindly give me 30 seconds, Milord? Only one.
Next matter.
Item number 8. Sir, I appear for the plaintiff. In your lordship's last order, lordship had directed the registrar original site to communicate with the official liquidator and to file a report. Serve a copy of the. This is a summary suit, my lord, arising out of a money claim.
The report of the learned registrar original site dated 10 December 24 shows that copy of the application was served upon the learned official liquidator. Full stop. The official liquidator order sheet টা কোথায়? None appeared for the official liquidator.
Paying, my lord, it's a summary process. The decree may be passed. It's a 14 crore decree arising out of dishonor of 26 checks.
Fixed for further order for hearing an order. Fixed 3rd March for hearing an order. A copy of this order may be communicated to the official liquidator, and the official liquidator is directed hereby to be present on the returnable date.
My lord, can we come back sometime in February? There's nothing.
After the passing of the order, you are appearing. I will not know to your appearance. The official liquidator shall be present on the returnable date. February 26th.
Great.
I appear for the petitioner in this application. Mr. Shuman Datta had started, my lord, arguing this matter. It's an application for recalling of 2 orders passed by a coordinate bench. The real issue, my lord, which would require consideration is whether there is a decree at all, and whether, my lord, the plaintiff should be permitted to my lord, proceed with the execution of the decree which has been allowed by these 2 orders. My lord, last time, my lord,
it was heard by coordinate bench.
No, this application, lordship had started hearing. Mr. Shuman Datta, my lord, learned senior advocate, is leading me in this matter. My lord, your lordship has heard Mr. Datta in part on, my lord, 29th of November 2024. He is engaged in another court today, my lord. If lordship permits us to come back on any other day, my lord, because
Sir, you are here.
I am opposing this application.
Last time it was indicated by Mr. Banerjee, who was representing the plaintiff and the respondent in this application, that possibly they don't have any authority to represent, my lord, the company because of a proceeding, my lord, initiated in the, my lord, National Company Law Tribunal.
On prayer of the learned counsel for? You are for?
Petitioner, my lord.
For the petitioner defendant.
Defendant petitioner.
Defendant petitioner. Hearing is adjourned to 4th March.
Decree execute property. Item number 10, 11 and 12.
Item number 11, will I appear for the applicant?
First, item number 10. Item number 10 is G8 9 of that has already been infectious. This application for the purpose of distribution of the liquid money lying in the bank. The bank account has already been taken possession by the partition commissioner. Therefore, this application is infectious and that may be disposed of. And secondly,
just a minute.
Without in item number 10, 11, and 12, I'm applying for the plaintiff. 10,
Distribute the liquid cash. Now this liquid cash is in the custody of the learned partition commissioner.
Partition commissioner, so that has been
No question of distributing right now.
right now. Without, and second,
No, allow defendant number 6, 7, 8 to let out the occupying portion.
no, that is another question. GA 9, this is the only for the
No, second para C, prayer C. Allow defendant number 6, 7, 8 to let out.
Well, that where I am not been press, only for the purpose of distributing those liquid amounts.
So this will stand as disposed of.
Disposed of.
The learned count you are for?
I am for the dependent number 1, 2, all of the dependent except 10.
I am for dependent number 10.
And this application has been made by the dependent number 8.
The petitioner of GA 9 and 2021, the learned counsel appearing for the petitioner in GA 9 of 2021 submitted that in view of appointment of the learned partition commissioner and in view of abandonment of claim for the time being as contained in para C of the prayer, this application has become redundant and may be disposed of. Full stop. For the time being, I'm making it for the time being. Because we may have raised this right in future. Let GA 9 of 21 stands disposed of.
But in the next matter,
just a minute. So 10 is over.
Over.
Now 15.
Dependent.
11,
Second. The dependent number 2 has been expired.
You have to take out application.
This is application.
Has expired 2 weeks back.
28 December 2022.
I'm for the plaintiff.
So you have to take steps.
No, all 3 and 4 are the legal heirs. They are already been party. So your lordship kindly expunge the name of the dependent number 2 on.
Learned partition commissioner. Next para. Mr. Dashgupta, the learned partition commissioner. Have you any death certificate?
Well, I am not offering the death certificate, but
Delhi, they will send it.
কি বললাম? The learned partition commissioner as well as the learned counsel for some of the defendants submitted that defendant number 2 has recently expired and legal heirs and full stop the legal heirs of defendant number 2 are already on record. Therefore, name of defendant number 2 be expunged. Full stop. For effective order, the plaintiff or any of the parties are directed to file supplementary affidavit containing the original death certificate or authenticated copy of death certificate for passing appropriate order.
Item number 11, my lord.
Yes.
This is GA 15, my lord, for addition of party. My lord, in that, my lord, 2 oppositions have been used. One by the plaintiff and one by the other, some of the defendants. Now, my lord, the plaintiff, my lord, opposition I have received it. I have also used a reply, my lord, I am filing it today. And my lord, the opposition, my lord, given by the other defendants, that has not been served upon me here. So
that has been served. But
give a copy.
I can give the copy.
I requested him to serve a copy.
Yes, I
have you filed affidavit in reply or not?
Affidavit in reply, my lord, is ready in respect to the opposition of the plaintiff.
Come with a single affidavit in reply.
Lordship.
In GA 15 of 2024, affidavit in reply shall be filed by the
applicants of GA 15.
By the applicants. Namely the proposed interveners.
Yes.
Proposed interveners. Next.
My lord,
GA 16.
GA 16 is my application, my lord. Recollect.
Just a minute, just a minute.
My lord could recollect that this is my application for recalling of the order wherein the advocate commissioner was appointed primarily on the ground that since I have been contesting this particular suit, participating in this partition suit since the time it has been instituted, Lordship, I was not even served with a copy of the application.
Which application?
The application by which the advocate commissioner was appointed.
What damage have you suffered?
My lord, this was absolutely on a technical point because there was very serious allegations raised against me. As I even submitted on the last occasion, Lordship, as an officer of this court, I cannot stand in the way if the court appoints an advocate commissioner for management of the.
It is submitted by the learned counsel. Next para. Submitted by the learned counsel for defendant number 1.
Defendant number 10.
Defendant number 10. That copy of the application. Which application?
GF 14, my lord.
GF 14
Of 2024.
of 2024.
Filed by the defendant number 12. Lordship,
Filed by the defendant number 12 was not filed up, was not furnished, served on him. Full stop. Copy of the application may be served on the defendant number 10 for effective hearing of GA 16 of 2024.
That in GA 16, a liberty was given to the plaintiff also to file and reply to the exception taken by the defendant number 10. I am filing that, your lordship.
Full stop. Exception filed by the learned counsel for the plaintiff.
Reply to the exception, your lordship.
Reply to the exception filed by the learned counsel for the plaintiff be kept on record.
But my objection be recorded regarding GF 14. All the parties have been served upon, then thereafter, my lordship passed the order.
If not served. Next, yes, Mr. Dasgupta.
By your lordship.
What is in your report?
The property in question, my lord, it was cleaned temporarily. Again, garbage has piled up, my lord. Inspection I found. So the
Rent was enhanced.
Rent was enhanced, my lord, more or less double. Some of them and the others are agreed they'll follow in due course, my lord. And my lord, the other tenancy, which is part of the suit property, the other premises, my lord,
they are handing over rent to you?
My lord.
All the tenants?
Not all the tenants, some of them citing illness and all this and that they will do so in the due course. That was that.
What are their names?
The names, one of them is.
Have you mentioned these names? Non-complying tenants?
Because some of them said that they just give us few days time, so I didn't mention my lord. They just take it just a
Report of the Learned Partition Commissioner, Mr. Dasgupta, be kept in record. It is stated that cleaning of garbage and keeping the premises in healthy and hygienic condition is in process. Full stop. Necessary steps shall be taken by Mr. Dasgupta to clean up and keep the premises in hygienic and healthy condition. Full stop. It is further submitted by Mr. Dasgupta that some of the tenants are paying rent to Mr. Dasgupta, while some others are not. Full stop. A list of tenants who are not cooperating shall be submitted on the next date, along with their existing rate of rent and occupied area. Full stop. Mr. Dasgupta shall also ascertain proportionate share of tax of all the tenants. A supplementary report, a further report shall be submitted on the next day containing these details, as well as the development of the incidents as may take place in the meantime.
May I indicate one point? submitting the report, my lord, the common place of worship is the Thakur God and the study room common statute still under lock and key, and it was the custody of defendant number 10. Last day when I inputted my he was not present, so I couldn't be able to.
Who is defendant number 10?
I am a
Please hand it over.
the common Thakur God and the common statute. And in
Or
front of them,
two things can be done. Either you will hand it over to Mr. Learned Partition Commissioner, or it would be open for common worship. It cannot be in your exclusive possession.
No, I'll seek instructions because the advocate commissioner is already there, my lord. I think it is better that in case of such a thing, I think.
I'm not reflecting anything on this one. Come on the next page.
the common statute and the plaintiff's bedroom, which is there's another entrance which is opening towards the study room. That is also closed. And piles of rubbish has been piled up. And I've indicated that in spite of telling them
Mr. Dashgupta shall also file a statement of accounts showing inflow and outgoing expenses, inflow of income and outgoing expenses incurred in administration of the estate. And how many money is deposited in the bank account, how many money is going out. Statement of bank account should be annexed therewith. Have you paid the remuneration? Where is that order? কোথায় orderটা কোথায়? How much have you received?
That, my lord, when the bank accounts were activated, my lord, I received it in the month of November.
30th April 2024 is the order.
What about your view of paying further remuneration?
As your lordship, I am.
Mr. Dashgupta may be paid further remuneration of rupees 50,000 out of the joint fund.
May I indicate one thing? My lord, just it has come to me from the plaintiff that another joint account that in the state of Animal Holding is lying there, the dormant, my lord. It was to fixed deposit, my lord. It was a amount of 2 lakhs, but it was there in the 2009, my lord. Till now, as verbally told to me, it's has accrued 4,38,000 in that fixed deposit as mentioned.
Why not the supplementary report? Mention it in the supplementary report.
I wanted to indicate this. My lord, and the other thing I wanted to indicate, my lord, the other premises in question, part of the premises is 11 Khilaf Coastal. There the four tenants are there. They are peaceful tenants, my lord. They want to just relocate the electric meter which is there. It's a very old.
Come with your report.
My lord.
First thing we need to ascertain how many tenants are there, how many tenants are paying rent, how many tenants are not, and their proportionate share in taxes, corporation taxes. They are liable to pay that.
Not that, my lord. The electric meters.
Maybe that will also be another issue. Mention it. Then what your counsel will say? If you say everything, allow your counsel to say something.
My lord, the matter is made returnable.
All these, no, 1 is disposed of, 9 is disposed of.
10 and 11.
But 15 and 16.
I'm sorry, 11 and 12. Item number 11 and 12.
The suit along with the applications shall appear in the list on 7th March. Copy of the report may be handed over to the learned counsels for the parties.
No,
Wait.
My lord, I beg to appeal for the defendant number 6.
Who is the plaintiff?
I appeal for the respondent number 7. I appeal for respondent number 7.
Who is the plaintiff?
I'm being led by Mr. Ram.
My lord, this is a suit where decree has been passed, my lord. Today, my lord, an application has been made by one party trying to intervene
After decree.
Well, that is the point, my lord. Initially, that is my point of maintainability. Because the decree has been passed. They had not taken any steps for any further inclusion before the decree was passed.
Whose application is this? After decree, how this application can be made?
Yes, that was subject to maintainability. I only appeared before your lordship. I said it's subject to maintainability. Because I would take the point of maintainability that the CS has been disposed of. Suit is no more there.
Yes.
Lord, may I advise you, lordship, Lord? The suit was, judgment was delivered, but
I don't know how Mr. Chakraborty has to say in this.
Lord, I am supporting the application, Lord. I tell you
Cannot,
why.
because the suit is not there.
Whether I can or cannot. that is
Affidavit in
out of
opposition shall be filed.
Filed before the action, but we have to file the reply.
Affidavit in reply is yet to be filed by the applicant. The same shall be filed on or before the returnable date. Affidavit in opposition.
But he's not the plaintiff. How can a defendant number 6?
All right, let there be a affidavit in opposition.
Defendant to oppose another defendant's application.
Let them do. Court will hear the merit. Let them do.
But my lord, your lordship will kindly make it known in this
Affidavit in
matter,
opposition
that there is
by
no
some
stay
of the
decree,
defendants are yet to be filed.
my lord, there is no stay of the decree. My lord kindly clarifies that. Because everyone is trying to file
I don't
an
know whether there is stay of the decree.
So
I
there
have
is
not
none.
passed this.
So my lord will kindly say that this order does not prevent the plaintiff from executing the decree.
কি
Lord,
বললাম?
the plaintiff has obtained the judgment. Thereafter, Lord, they got the judgment modified post decree. There is a post decree amendment. This application was filed before that.
Same shall be filed on or before the returnable date.
Affidavit in reply shall also be filed. Let this suit appear in the list on 6th March. Now, look, one thing I cannot understand. Suppose the application is allowed. Then what will happen? You will be arrayed as a party, dependent on plaintiff. What else will be done?
My lord, this is a second bite to the cherry, my lord. First, my lord.
Let this be allowed for the timing. Let this be allowed. They will be added as a party. What else will be done?
She has been set up, my lord, by the other defendants.
You have to file an application for setting aside a lie. Anyway,
No, Mr. Rai is now
it is made clear that there is no stay.
Perhaps it is not required.
Oh, it is made clear that there is no stay on execution of the decree.
Grateful.
Item 14.
Chalo, take the court sheet. Chalo. Affidavit file court sheet.
I appear for the plaintiff in this matter, my lord. And on the last occasion, your lordship has heard the matter and have the hearing was concluded. I have also filed my
No issue is there.
issue.
I am not able to find any issue.
My instructions are there are orders. There is an order.
Where is that order?
Since your lordship has raised this query, my lord, if your lordship gives me 2 days of time, I'll find out.
Because at the time of I was sorting with the documents on the cost papers. I am not able to find any issue.
I'm instructed that there was order where it was long time back, maybe in 2014.
So let it. I'm fixing another date. If issues are not adequate, I have to check
Your
the
lordship
written
will raise
statement.
the issues in that. Your lordship
Yeah,
will
so
raise
discuss the issues.
in any
On
case,
prayer of the learned counsel for the plaintiff, the matter is adjourned to 17 January. 17 January is okay? 17 January. Oh,
my lord, my advocate record has got some issues regarding 17. So any day after 17,
21st January.
21st January is very.
Item 15.
In item 15, your lordship,
My application
I'm
filed for revocation of probate.
So I'm being led by Mr. Sarvopriya Mukherjee. He's not here this week. I was humbly praying if this
I
can be
can
taken up
start,
on
Lord,
Monday.
I can start. Lordship heard the matter on the
With the application.
Yes.
When probate was granted?
My lord, probate was granted, my lord, on 15th of March 2019.
15th of March?
2019. My lord, in the probate proceeding, my lord, the respondent who is the executrix, my lord, has shown that a consent affidavit has been given by the petitioner. And using that consent affidavit, my lord, the probate was obtained from this honorable court, my lord, on 15th of March 2019. My lord, kindly takes page 17 of my application.
No, your first argument whether it is barred by limitation.
No, my lord, probate was granted on 15th of March 2019.
2019?
Yes, 15th of March
Okay,
2019.
okay, 19. Then it's within.
Petition was filed in 2021. Now, my lord, the basis for grant of probate, or what was the case of the executrix before the probate court at the time of grant of probate?
Your main allegation is forgery and fraud.
Yes.
Signature
Because-
was forged and fabricated.
Yes, the reason I say this, my lord, if lordship will kindly take page 18 onwards of my application, this is the purported consent affidavit used to obtain the probate on 15th of March 2019. But I would humbly beseech your lordship to kindly see, my lord, the affidavit which is at page.
Affidavit is forged.
Yes, the signature is forged. The reason I say this, kindly see, my lord, page 18, the document starts. Lordship will find, my lord, the signature at page 19.
Sangeeta Savadia.
Yes, Sangeeta Savadia. My lord, I am one of the daughters and my signature has been obtained. Now, my lord, why I say that this document is forged or my signature is forged? Because, my lord, between, if lordship will see, between 5th of April 2018 to, my lord.
Yes, I've heard it possibly.
Yes, lordship heard it on the last occasion. In fact, my lord, I was drawing reference to page 11 of my application that would show, my lord, that on the date of preparation of the affidavit.
You are not there. Yes, yes, I can remember now.
Yes. The affidavit is dated 11th of December 2018, which starts from page 18 onwards.
Yes.
It has been notarized on 11th of December 2018.
All right, let me hear Mr. Mukherjee first. I have heard you. Two issues. You are not there, first thing. Second thing, signatures were forged.
Yes, and my lord,
So let me hear Mr. Mukherjee first order.
One submission more, my lord. The original signature, because at the time of affirmation of the petition for revocation, my client had come to the
Yes,
court.
that's why it will be sent to confirmation or it will sent for comparison or examination.
Very well. Lordship,
Let
yes,
Mr.
lordship,
Mukherjee come. Let me hear Mr. Mukherjee.
Any day next week, Your Lordship. He's not here this week.
Adjourned to 14 January.
But in the meantime, well, lordship will kindly lordship will kindly pass an order that the documents be examined by an handwriting expert.
No,
and a
not
report.
now. Let me hear Mr. Mukherjee.
But my lord, I need to. My lord, I had few submissions to make and few judgments to cite. The reason is, my
It's
lord,
a question of fact whether these signatures are yours or not.
yes, it's not.
That's why that is your point raised by you.
Yes.
That's the first question of fact. Second question of fact, you are not there.
Yes, I was not there.
So for ascertaining or deciding the first issue, signatures are to be sent for examination.
Yes.
This much. What judgment will you show? 14 January.
Grateful, Lordship.
Item 16.
Yes, my lord.
Item number 16.
Yes, my lord. This is a very old matter of 2011. The matter has already been disposed of by Honorable Justice Krishna Rao by order. But one thing, my lord.
For bond.
For bond. For executing only one stage is incomplete, that is execution of bond. And when I applied to the register for appointment of an officer, the register for some reason or other told me to bring an order from this honorable court. Accordingly, I have filed the application. But as per law, to my concern, it is not required. Everything has been completed. Only one commission is required to be done.
Department come on Tuesday.
On Tuesday, my lord.
Tuesday, let me ascertain from the department why it is not done.
But as per chapter 35, rule 19, attestation should be given by the register as per my
Yes,
knowledge is
let the
concerned.
registrar, let me know
But
from the
register
registrar.
told me to come before your lordship.
All right, let me know why the registrar did not do it.
Yes, my lord. Much obliged. On Tuesday.
Tuesday, 14 January.
14 January. Much.
17.
একটু
Item
ডেকে আনো তো
17.
প্রেসিডেন্টের দিকে আছে রাখো।
Your Worship, this is my application for conversion of the probate proceeding into a letter of administration and also for recording the death of the legatees and for substitution of the legal heirs of the legatees. Your Lordship, by a GA 3 2023, the previous GA, made by one Sasanta Kumar Dutt, there was prayers being sought for the substitution of the legatees, which was also allowed by an order dated 26 July 2020, which is appearing on at page 46 of my application. But the same could not be carried out as the applicant in that application.
They are all parties. We are speaking of substitution. This clearly. What substitution is to be made? They are not parties yet.
They are legatees.
Legatees, they are not parties. Then why substitution is to be made?
At para 5 of the probate application, there the
Then you have to file amendment application.
Yes, for substitution and amendment of.
File amendment application. This is not the application.
Yes, this is the amendment application, Your Lordship.
First, you come with an amendment application, record the date of, and your prayer is
to record the death of Prasanta Kumar.
Substitution. Your prayer is substitution. There is no question of substitution. They are not parties.
Prayer D. Part portion of the petition be amendment in consequence of the changes mentioned in prayer.
Part
portion of the petition be amended in consequence of the changes mentioned in prayer B and C.
Prayer B is to record date of Prasanta Kumar Dutt.
Yes.
Being legatee number 4. Mentioned in para 5 of the petition. So, in order to do that, you have to file application for amendment. Second thing, recording date. They are not parties. You can't understand me. File amendment application.
Your Lordship, this is probate. It is uncontested probate.
Yes.
They will not be
So,
subject to correction, whatever possible.
So,
Your Lordship,
they are parties here.
they have given the consent affidavit.
They are parties. They are defendants. Then, what to be substituted?
In the probate application, the legatees name.
Can't understand. The application GF4 of 2024 is returned with the direction to file appropriate application with appropriate prayer. GF4 of 2024 stands disposed of. Next matter.
If the matter can be adjourned for a day, I will come with a necessary instruction.
Item 18 and 19.
On behalf of the petitioner.
My lord, in item number 18, my lord, I am appearing on behalf of the plaintiff. It's a testamentary suit, my lord. It is their application.
My lord, we actually first complete that is my application, then he will get his chance.
This is not maintainable, my lord, in the wake of the previous orders passed by this very court, my lord.
Then why did you allow him to file it? You should tear it away.
First of all, my lord, I am led by Mr. Siddhartha Banerjee in this matter. I have been told that he will be appearing online, but stuck in court number 17. This is an application for pointing out certain
exchange of affidavit is complete.
Yes. The exchange of affidavit is complete. There was earlier direction for filing a supplementary affidavit, which I have also filed after serving a copy, my lord. My lord, Mr. Siddhartha Banerjee is there. My senior is there.
Mr. Dutta, please carry on. I will immediately reach the court. You please carry on. Please carry.
I just point out I just jot down what are the essential facts and what are the essential things which are involved in this particular application. That is actually the defects which has been made by the probate petitioner who has been substituted after the death of his mother. In that particular application, the amendment how he has made and thereafter the amendment that has been carried out, there are certain defects in those amendments. When Honorable Justice Shoman Sen has passed an order, which my lord will find at page
99.
My lord, at page 98, 99, my lord has said that the at the third paragraph of the order, my lord.
The order, however, does not decide.
Yes, it does not decide the merit of the application and how the conversion has been made from an application of grant of probate to an application of letters of administration. That is from an application under section 276 of the Indian Succession Act to application under.
All right, let me go through these applications in details. Come next day. Hard in part adjourned to 6 March.
The next application, my lord, the GA 29, my lord, is
to file an affidavit in opposition to that application.
Affidavit in opposition
my lord,
in GA 29 of 2024 shall be filed within 3 weeks. Affidavit in reply, if any, within 2
my lord,
weeks.
in the meantime, my lord, I have sought for one leave in that particular application, my lord. Let me just place that, my lord. This application is made for seeking the removal of the administrative pending liability, my lord. So I have sought for a leave to serve the copy of the application upon him.
Application may be served
On the administrator, my
GA
lord.
29 of 24 may also be served upon the present administrator pendently.
Yes, my lord.
That matter.
Yes, this is, my lord, someone's application whom we say, my lord, have nothing to do with the matter.
Be that as it may, my lord, I have been saying that with regard to them as well. Their client has not yet come before the court ever, my lord.
A part of these issues, some of the issues were decided by us.
Yes.
But the issues have been framed already, and they're coming with a demurrer application of an order which was.
They have lot of issues.
But many
Some
issues
are framed. Some issues
But
are outside this court.
My lord, who is masquerading as their client, my lord, that needs to be found out.
Yes, with him.
not, my lord, not yet, my lord, thankfully.
Item 20.
This is my application for judgment upon admission. For judgment upon admission, my lord, claim admittedly, my lord, amount paid is rupees 50 lakh. Defendant did not file a written statement.
My lord, in this matter, Mr. Somnath Gangopadhyay is appearing on
Appearing, my lord, this is the third time, my lord, it is happening, my lord. I am objecting to any.
My lord, it's admitted
This is the plaint.
My lord, kindly look at, my lord, the plaint question. There is a.
Get a plaint.
My lord, kindly take, my lord, the application.
This is plaint. Application ta kothay?
Kindly look at the application.
Just a minute.
Lordship, here. The application. There is an application in a suit where, my lord, the defendant's application for, my lord, to take on written statement, my lord, on board has been rejected in 2013. Thereafter, my lord, I have a certificate.
Just a minute. Let me go through it. Where is the admission?
Lord, kindly, my lord, takes my application once. Kindly have a admission which are there in, my lord, his lawyer's statement, my lord, which lordship will find annexed, my lord, to the document in question. Kindly, my lord, takes, my lord, the admission. It's a chapter 13. I did not go per se with the admission, but the admission is there. My lord, kindly have a look at page 68. Has lordship found page 68? A letter of Mr. B.K. Das, written to us, who was the erstwhile advocate on record of my learned friend's client. As per the discussion, it's an undated letter. As per the discussion you had with Mr. Sudhir Kumar Ghosh, you means the plaintiff, and Sudhir is the defendant. The chamber wherein Sudhir Kumar Ghosh had agreed to revoke the agreement of transfer of.
This is chapter 13A application.
Chapter 13A application. I have to only show, Miller, there are no tribal issues.
No, that's separate issue. First thing, whether have you filed an application to defend?
No. Chapter
My lord,
13,
just-
they will have an opposition. That's what
Yes,
I'll
we
show
will have
that.
an opposition, my lord. The only difficulty is that the advocate on record is admitted in the hospital today, my lord.
Third time. It's
My
the
lord,
third
it's
time.
an emergency. How can
Miller, last time also emergency, Miller, I did not stand in the way. This is very unfortunate. Every
Where
day
is
they
the
come.
objection?
Sir, kindly take the objection. It's a thinnest Miller objection in question.
Step karo.
Okay. Sir, this is an affidavit. The objection is very Miller short. The Lordship takes the objection one. Sir, has Lordship found out the objection? The objection is contrary to this letter in question. An affidavit in opposition of Sudhir Kumar Ghosh himself. And a draft sent to me, I have accepted the draft. Kindly have a look at paragraph 7. What had happened, there's a Sanjeevani nursing home in Shambhajar. I was Miller supposed to get possession of the 5th floor. I did not get, but I have paid Miller 55 lakhs. Miller, there are disputes and differences between the parties. I did not get the position. I did not get the tenants. If that be so, Miller, I was to pay 1.55 crores, Miller. Miller, I had paid 55 lakhs. Agreement, Miller, cancelled, Miller, by Mr. Ghosh.
No, this is a suit filed by you.
For recovery of Miller, the balance sum.
Balance sum.
Miller, just Miller. There was an agreement for assignment of tenancy right in respect, Miller, of a premises, Miller, in Bhupen Koshavi. Lordship has heard the name of Sanjeevani nursing home. It's a doctor's, Miller, disputing. So, Miller, a tenancy in respect of 5th floor was supposed to be given, assigned, Miller, to be the plaintiff hearing. For in lieu of the consideration thereof, the amount was rupees 1.55 crores. We had paid Miller sum of rupees 50 lakhs plus 5 lakhs admitted. Rest Miller was not paid because Sanjeevani did not leave the position of the 5th floor in question. There are equipments there. I did not get the position. Miller, a power of attorney has been executed in the favor of.
Now you want back this 55 lakhs.
I want back the 50. Either I get back the possession or I get back Miller my money. He says that there is equipments in the 3rd floor.
Have you filed an application for chapter 13?
I have filed an application.
Where is that application?
This is the application which Lordship read.
Oh, this application. That is GA?
Millard, kindly take Millard, my application, GA number 455 of 2012. Because Millard, that point of time, GA was Millard in respect of our total.
GA-টাকে নতুন নাম্বারটা লেখো এর মধ্যে খুঁজে খুঁজে ভাবে দেখতে হবে না।
Now it's GA2. Millard, this is Millard. Kindly take Millard page 68 once. There is no explanation to page 68. At least they have to secure, it's an undefended suit. Lordship knows the judgment of Rahul Shah, which says, Millard, that Millard, you have to secure in case of this type of admission.
Ready to return 50 lakhs. Is it in your plaint?
Yes. More than that, I have other claims.
No, is it in your plaint?
This plaint is annexed here to the application itself.
Is this letter annexed?
Yes, this is entire plaint is annexed. This is part of my plaint, in fact.
Where is that
Which
letter?
your Lordship says takes is a part of my plaint.
Where is that letter?
Kindly look at my plaint itself. At that point of time, Lordship will not find plaint had any action because this was not a commercial suit. Kindly have a look at my plaint in question. Admission regarding payment of money. Para 16. Para 17. Para 18. Kindly take page 25. Para 18. This is the document by an undated letter addressed by the plaintiff, learned advocate acting for the defendant and received by the plaintiff sometimes in first week of October 2008. It was confirmed that the defendant has agreed to revoke the agreement.
That this particular letter is the basis of all your claims.
Yes, not for part of my claim.
This is for return of money.
Return of money. Whatever
But not for compromising your claim or settling your claim in respect of possession.
Yes. Millard, possession, Millard, I am foregoing my right of possession.
So you want your money back only?
I want my money back with interest. This is all my claim, Millard. What remains of the suit
And this is pleaded in the plaint. There is no written statement.
They have denied the content of the application.
They, how they deal with that, Lordship will take his opposition once, affidavit in opposition, how they have dealt with this part. Kindly have a look at paragraph, if your Lordship kindly have a look at paragraph 17, which letter I have shown. Or kindly takes para 20, how he has dealt with para 20. Para 20 is the application, there is no written statement. So far as the plaint is concerned, that's uncontroverted. So far as paragraph 16 is concerned, kindly have a look at paragraph, how he has dealt with paragraph 20. That's paragraph 27. Or paragraph only denied. Kindly take paragraph 31, page 17 of the opposition. The defendant states the return of the said act was obviously
Para 17.
Paragraph 31, page 17 of the opposition. The defendant states the return of the said sum of 50 lakhs was obviously conditional upon return of the equipments by the plaintiff to the defendant. The plaintiff having cancelled the said agreement dated 6th October 2007. Well, I did not. They cancelled. Their advocate could not seek return of custody of the equipment, same time claim return of the refund of the amount allegedly paid back. Defendant states that the value of the equipment was 1.5 crore and without returning the equipment or the value thereof, the plaintiff could not possibly claim refund of the amount allegedly paid. The contents
So it's a kind of counterclaim, though no written statement is filed.
No written statement filed. Lordship will kindly test it with page 68. Kindly test it with page 68. Is it conditional upon returning of the equipments? I am entitled to file application.
I got your point. Yes,
for making this false statement on oath.
All right.
Millard, kindly, if I just read Millard for as per discussion with Mr. Sudhir Kumar Ghosh at your chamber, wherein you and Sudhir Kumar Ghosh had agreed to revoke the agreement and transfer the tenancy and power of attorney between Sudhir Kumar Ghosh and you, provided Sudhir Kumar Ghosh is agreed to return the same earnest money of you. I am enclosing a draft copy for your consideration and receipt of your acceptance necessary and revocation. And kindly, this is a draft copy at page 69. Lordship, they have given Millard and my.
There is no such condition in that letter.
And I've agreed at page 72. I say, give me 55 lakhs. I have paid you 5 lakhs more.
Heard Mr. Ghosh in part. Adjourned to 17 January for further hearing. If you are able to come, very good. Otherwise, I'll pass order.
And today there is no written statement.
When the learned register original site, it is 17 shall furnish a report on date of service of summons.
So that report is already annexed to my petition.
Last report. I want a last report. Sometimes written statements are filed in the department. Date of service of summon, date of appearance of the defendant, as well as date of filing written statement, if any.
Well, that report is there. I have already.
Let me have the current report.
Correct. Very good.
On the returnable date. Let this suit appear in the list on
except 21st any day.
28th January.
Grateful.
Item 21.
Madam, for the plaintiff. For the defendant, my lord, by the order dated 2nd December 2024, Lordship had directed the department to furnish a report as to whether defendant had deposited money in terms of Lordship's order of setting aside of an ex parte decree. But pursuant to the, I do not know. According to my instruction, they have not deposited any further money after this order. And till this order, they had deposited only 10
Report of the landed register original site dated 9 December 24 be kept in record. Copy of the report may be handed over to the learned councils.
In view thereof, if they have not met print, then the decree will
take it. File appropriate application if necessary.
My lord, we have preferred an application for clarification, my lord. My lord, let me give.
Let the copies be given.
Very well, my lord.
let the matter appear in the list further on 14 February.
Grateful to your lordship.
22.
To appear, my lord, on behalf of my lord, the caveator son of the testatrix.
It's a hearing on caveat.
My lord, this is a hearing for an application for discharge of caveat. My lord, before I start, my lord, may I indicate this matter was taken up before another coordinate bench and it was heard at length, where I have concluded my submissions. My learned friend was
The
also.
matter is released from this court for placing before the coordinate bench, which heard it extensively. এটা রিলিজ করে দিলাম
23.
My lord, I'm
But
appearing
this was
for
also
plaintiff,
fixed.
my lord. There's an application GA10 which I have filed praying for injunction. My lord, on the last occasion, Mr. Shorbukwe Mukherjee had started.
But this was taken up yesterday.
Yes, my lord.
And
He had
this matter
already
was fixed for
started
witness
his,
action today.
The suit has not come, my lord, today.
Yes, it has not. But it was fixed for witness action.
My lord, I'm praying, my lord, Mr. Mukherjee had to urgently leave town. My lord, he's requested if
No,
it can
no,
be
my lord.
taken up on Monday, my
was
lord, by
taken up-
Mr.
application.
Mukherjee, I know Mr.
Yes,
Mukherjee in
my
the previous matter also.
Yes,
Yes,
my
my
lord.
lord. Now, my lord, I'm only on one.
Already made part submissions in this application.
This was taken up yesterday when this submission should have been made and
before
indicated.
yesterday, my lord,
Day before yesterday, it should have been indicated.
My lord, he had to leave yesterday only, my lord. He's requested
When he will
if it
come?
can be. My lord, he had to leave for Delhi urgently, my lord. He's
When he will come
My
back?
lord, Monday, my lord. He'll be here on Monday. My lord, he's requested the matter be kept on Monday.
Monday I will not be there.
My lord, Tuesday, any day, my lord, next week.
Adjourn to 15 January.
My lord, I'm also praying, my lord, let the matter appear on any other day for the purpose of witness action which was going on. I'll just indicate why.
When the suit will appear?
But it was supposed to appear today.
Yes, my lord.
This is the order. It was supposed to appear
The
today.
suit will appear in the list
Not come.
for witness action
Yes, my lord.
on 7 February.
Grateful, my lord.
না ওখানে লিখে দাও কি বললাম অর্ডারটা for hearing GA10 of 24.
Yes, my lord. On 15 January and the suit on the 7th.
Grateful, lord.
7 February.
Grateful.
Yes.
24.
I appear for the petitioner, my lord. In this matter, my lord, this is my petition for contempt. My lord, my lord, contempt of my lord's order dated 31st.
Why the contempt application should be entertained?
My lord, because there's a violation, because there was an order
Right,
of
there is
injunction.
violation of the order.
Yes, my lord.
Then what is the problem? It's a violation of decree.
Yes, my lord.
Then-
My lord, here, because there is a question of injunction, there was two parts to my lord. I'll just take my lord to the operative portion.
There is a decree of permanent injunction.
My lord.
Then how the decree of permanent injunction should be dealt with?
My lord, there is no scope for execution. This is a question of after knowledge they're violating the order, my lord. Had it been a
That's why execution is to be dealt with. Execution is to be taken up.
my lord,
File up execution proceeding, a contempt
my
proceeding.
lord, I will kindly try to satisfy. My lord will kindly keep it on. I will come with judgments on this, my lord.
Number of judgments are there.
My
Where
lord,
says in spite of execution proceeding, contempt can be taken up.
My lord.
But for example, in Daiji's case and other cases are there, but those are distinguishable.
My lord,
Facts are
this is like
distinguishable.
willful violation of the order in
Who
spite of
doesn't
knowledge,
know?
my lord.
On all these cases, some undertakings were given to the court,
My lord.
and in spite of that, it was violated. Here it is ex parte.
My lord, in spite, but the order exists, my lord, and there is a willful violation. After knowledge of the order, they are violating.
That's why you go with the execution. Even when you will pursue the execution proceeding,
My lord.
two options will be open to you: arrest and attachment.
My lord.
Here only arrest. What will we do?
My lord, but nothing prevents me from pursuing this relief, my lord. That is my.
If
I'll
you
come back
pursue,
with
I will
judgment,
pass
my
order.
lord. You kindly keep one date, my lord. I'll come back with the judgment, my lord. Short date, I'll satisfy. My lord.
Adjourn to 7 February. Basically, this is not tenable.
My lord, satisfy.
I know number of cases are there, but specifically at this case, the contempt cannot be a substitute of execution proceeding.
My lord, I'll come back with it.
for arguments, item number 25 to 28.
My lord, I beg to appear on behalf of the plaintiff, that is EPJ Private Limited and EPJ Shipping. EPJ Shipping is in 26. Well, two suits by us and two suits by. Two are APJ Private. One is APJ Shipping. The other is Surendra Overseas. Well, the amendment application has been allowed. The amendment is to be carried out. It is in their state. That has to be. Amendment. All the four planes are amended. Three have been amended.
The names of Surendra has changed.
Well, only the names have been. Which name? Surendra Overseas. Surendra Overseas. Item number 27. Surendra Overseas name has been. Surendra Overseas to APJ Shipping. That is 27 only. Yes. 26 is APJ Shipping. Yeah. Is it changed 27 and after it? Have to do one thing, make a compilation. My lord, what happened, I tell your lordship, it struck your lordship's mind a few months back. And since then, my lord has been taking a lot of trouble so that the course papers could be brought before your lordship in a consolidated manner. There, I have seen there were 3 trunks of documents, including the deposition and exhibits.
In all connected.
All connected. This matters. No, my lord. Kindly take up the matter. We all want the matter to be heard and adjudicated finally. This matter will go on releasing them. Kindly do. Because we have, don't say trunks. No one will hear this matter. Now, my lord, my lord was pleased to direct the department to prepare paper book of the documents. Now, the department has prepared the paper books.
But I will also check up.
Amendment application was allowed.
No,
only 20. With regard to item number 27, it is pending. It's not fine.
So I'll have to check, my lord, possibly that amendment.
78.
In 27 and 28, I am the plaintiff.
EPJ Private Limited is there.
Is there, I believe.
EPJ Overseas is not there. Surendra Overseas has to be read as. We have to file that.
For change of name.
Yes.
Right, I'll.
It is granted in CS 170 of 1965 to the plaintiff to file appropriate application for amending the name of the defendant. No. Fix all 40 suits. All 40 suits are adjourned to 27 February. All the 4 suits are adjourned to 27 February. And my lord, in the meantime, let the department continue with their work.
Because by the last order, my lord's last order.
Which is the order, parent order? Well, kindly come to your lordship's order dated 20th November 2024.
Department is directed complete reconstruction to complete the process of reconstruction of record in the internet.
And my lord, a report be called for so that we can also ascertain what is there, what is not there.
With liberty to mention.
Great.
Parties are at liberty to, London councils are at liberty to mention.
My lord has been pleased to direct the matter to appear on 27th.
27.
27.
All four parties.
Actually, they continue. Yes, sir. Yes.
Witness action, item number 29.
Matter, but the defendant's witness is going on, my lord. Deposition of DW is going on, my lord. I am for the plaintiff, my lord. My lord, actually, they are not cooperating with the honorable court as well as, my lord, the proceeding.
My lord,
Where is your witness?
my lord, you had to file an my lord, you have to file an appropriate application for withdrawal of documents, my lord.
My lord, liberty was there, my lord. I passed by your lordship, my lord. Even, my lord, in spite of order, my lord, they have not taken any steps, my lord. I suit for eviction, my lord. I have been suffering, my lord.
On prayer of the learned counsel for the defendant. Matter is adjourned to 6 February.
Item number 30.
Lord, I appear for the defendant.
My suit, my lord, is that matter, my lord, which I mentioned yesterday, my lord, for my lord fixing.
Lordship was pleased to keep it on the 7th of February.
I don't know, my lord, why is it appeared today?
7 February. So date for.
No, my lord, now that the matter is appearing, lordship may pass an order now. Yesterday I was insisting on an order being passed. my
Lordship
lord.
will kindly record that the cross-examination of the defendant's witness is to continue on the 7th of February.
But 10th, the matter did not appear.
The suit will appear in the list on
7th of February.
7th of February for further cross-examination.
I'm grateful, Lordship.
Of DW.
Company matters, item number 31.
I appear on behalf of the applicant. Lord, my application. Lord, on the last occasion on 28th November, Lordship had directed us to serve the state of Bihar. Lord, they're not appearing, but very briefly, my lord, may I indicate what the application is? My lord, there's no adjudication as such which is required in this application. There was an earlier order which was already passed by another coordinate bench of this honorable court, my lord, directing the state of Bihar to carry out certain rectifications in the record of rights. My lord, that rectification was not carried out despite the order. Yes, my lord. Yes. My lord, that is, my lord, the AC market matter. My lord, Shakespeare Sharoni. My lord, or the Order 7, Rule 11, Lordship is talking about. Commercial disputes. Yeah, my lord, that is the Order 7, Rule 11, which I was moving before your lordship. My lord, Mr. Singh was on the other side. My lord, wherein, my lord, I was submitting. My lord? Order 7, Rule 10. I'm grateful. Yes, my lords. Lord, that your lordship has perhaps kept for next week. My lords, my lord, I'll give the number, my lord. I'll give the number to my lord's officers. Yes, yes, my lord. Yes, my lord. Lord, coming back to this, my lord, adjudication has already happened. My lord, another coordinate bench had. Yes, my lord, I'll tell your lordship. Application is for directing the state of Bihar. My lord, the order, your lordship will kindly come, my lord, to page 59 or 58. Sorry. Yes, 59, my lord. My lord, this was the order directing the state of Bihar, my lord, to carry out the rectification in the record of rights. My lord, because the difficulty I am facing is I am not being able to sell these plots to intending purchasers without the rectification being carried out. My lord, the only problem was there was no time limit which was prescribed for the state of Bihar to carry this out. That is the reason I've come up before my lord, seeking a direction upon the state of Bihar, to carry out the rectifications in a time-bound manner. Rectification, lordship will find, the judges summon, if your lordship, oh, may I show lordship the judges, prayer A of the judges summon, I'm carrying a copy. Take to lordship. This was, prayer A which was granted in my favor. Yes, Lord. Prayer. Prayer A, lordship has already allowed pursuant to the order of 28th November 2024, my lord, I'm filing my affidavit of service. They're still not appearing. May I file the affidavit of service? My lord, 28th November, last order, my lord. Yes, my lord. Yes, prayer is for service, my lord. Lordship will have a look at the master summons. My lord, I filed it, my lord. I just. So this is fine. And appears for state of Bihar. Copy of this application along with order dated 28 November 2024 as well as the present order may be served upon the Chief Secretary, the Government of Bihar, as well as upon the with that person. If it is not, then mandatory this as well as of the Principal Secretary. Where we served the Principal Secretary on the last occasion. The Principal Secretary, Revenue and Land Reforms Department. Principal Secretary, Revenue and Land Reforms Department, the Government of Bihar, by the registered original site. Six. 28 February. A shorter date. Report by the registered original site. On service. Case. After proper service. 8th of Bihar fails to appear. The petition will be heard expurgated. Lord, may I only request for a shorter date, Lord, if your lordship. Lord, I'll tell your lordship what the problem is. Lord, the land is being, Lord, people are coming and occupying the premises. 18th, my lord. My lord, order has already been passed. Lordship only, Lord, because there was no time limit fixed, that is why I cannot come up in contempt. Otherwise, I would have come up in contempt before your lordship. I'll come back, my lord. I'm grateful.
32 and 33. In 32 and 33, the CA68 is my application. CA68 is my application. The lordship may kindly see what has happened. I will show the three orders.
Lord, Mrs. Smita Das is appearing for the official liquidator. She is busy with other courts, my lord. Short passover, if your lordship is
Not
passover, not today then.
My lord, I will make a small prayer. I'll show two orders. Lordship may kindly come to page 31.
31 of your application?
My application.
ওইটা কোথায়? That previous order.
Previous order. The lordship kindly turns to page 32. this matter, the BIFR matter was in its entirety transferred to NCLT. Now, challenging this, an appeal has been filed. Now, the file in the interregnum had been transferred to NCLT. Lordship kindly comes to page 41, page 44. The Lordship kindly comes to the operating portion.
I understand your point. Let the learned counsel come, making it not today, not this week.
No, I am seeking only one direction. Lordship will not be able to take up the matter till the entire file comes back from NCLT.
I will pass order on Tuesday or Monday.
Lordship.
If I am not sitting on Monday, then come Tuesday. Tomorrow there will be no company matter.
No, then it will be on Tuesday.
Monday or Tuesday?
Lordship then keeps it on Tuesday.
Tuesday.
Because I'll be seeking only simple order directing NCLT to retransfer the entire record.
All right. Let them come.
Item 34 and 35.
I'm for the official liquidity.
Lordship, I appear on behalf of the applicants.
Application for?
Lordship, my application is praying for execution and registration of a sale deed of conveyance with respect to a self-contained flat.
Yes, what I have to say?
But the official liquidator has nothing to do. The official liquidator was appointed as a professionally officer. But maximum matter is pending before the NCLT. NCLT has appointed the resolution professional to represent the company in liquidation. The company in liquidation, they are the promoter directors. They have constructed several buildings and they have also.
You do one thing, you file a supplementary affidavit giving all these things.
Yesterday also your lordship was pleased to direct the official liquidator to file a report. So if your lordship kindly direct, I can file
a report. May be filed by the official liquidator in respect of CA.
Your lordship, on the last occasion, your lordship had directed to serve the application on the resolution professional. We have done this.
Affidavit of service?
We will just, it's coming, it's on its way, we'll just
All right.
file it. Your lordship, also I would like to point out that there have been several applications in the same manner, and those
a report in respect of CA 79 of 2024. The official liquidator shall furnish a report on CA 79 of 2024. Full stop accommodation is sought for by the petitioner to submit to file affidavit of service. Accommodation is allowed.
Your lordship, if I may point out,
Come on the next date. Adjourn to 25th February.
Both the matters, my lord.
Both the matters.
And give it.
In item,
Combined. That matter is come on Tuesday.
my lord, there's a very short point involved here because they want the execution of the deed, my lord, and now they are coming after a considerable period of time. So we are not standing in the
Which
way.
one? Which one?
31, my.
Lordship, which
32, 33, my lord.
directs the NCLT to retransfer back the
But
record.
the only one thing is this, my lord. They want they should be in the name of the nominee. That can't be because
That
there
will be
is
decided once the record comes. Let that be decided.
record has not come.
No. Unless the NCLT said, unless there is a specific direction, we cannot retransfer back the record.
Then my lord gives the direction for the transfer of the.
If we call back the report from NCLT, then that will hamper or impede the proceeding there.
No, my lord, because already there is an order of stay from the appeal court. So that is why
Show me that.
Yes, Lordship kindly
Come in the form of make this form substantial statements in the form of supplementary affidavit. I will pass order. Come on Tuesday.
Lordship, that is there already. Order.
It is there.
Yes, page 44.
Wait it out. Page 44.
Page 44 of my application. That's the Honorable Division Bench's order. Lordship kindly comes to the page 45, third last paragraph. In those circumstances, the company is almost on the verge of death with no chance of revival in the words of Supreme Court in such and such. Hence, in the interest of all stakeholders and the interest of justice, the winding up proceedings should be continued and concluded before the learned
So,
judge.
NCLT is ruled out.
Yes, my lord.
It's completely ruled out. Now the records in
For effective hearing of GA. Sorry, CA. কোথায় গেল নাম্বারটা?
CA 68.
68 of 2024. and in view of the order dated 9 January 2024 passed by the division bench, wherein direction was given that winding up proceedings should be continued and concluded before the learned single judge, record of the proceeding may be called for from NCLT, Kolkata.
Yes.
Kolkata. Kolkata or Calcutta? What do you write?
Kolkata.
Kolkata. NCLT is Kolkata.
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 Except this honorable court, everything is Kolkata.
Chartered high courts are same.
Yes.
Bombay, Madras,
Yes,
Calcutta. Because here we took a resolution in a full court meeting that name should not be changed to Kolkata. It will continue to be Calcutta.
It's by the Queen Victoria's original proclamation.
No, we should not change the name from Calcutta High Court to Kolkata High Court. There is a full court resolution. You will know? Copy of this order may be communicated by the learned registrar original site to the NCLT Kolkata. Let the matter appear in the list on 3rd March.
I'm obliged.
Deeply obliged.
তাহলে ওইখানে যেটা বললাম